need nerves of steel and a very, very high level of independence to stand firm against this kind of onslaught that is brought to bear on them during the trial. How much time do I have? Okay, okay. I've told you that very often the judiciary is a silent collaborator with the government in these terror cases. I'm going to give you two examples. I've given you a few so far, but these two put themselves in a different league. Now, during the confirmation hearing, the death sentence confirmation hearing of Ajmal Kasab in the Bombay High Court, the Bombay High Court appointed two lawyers, very senior, good lawyers, as amicus curiae to defend Ajmal Kasab. They wanted to meet their client to get instructions. Now, how do you do a death case without meeting your client and asking him what happened? Asking him what are the mitigating circumstances of your case? So they went to the jail to meet their client. The jail authorities did not allow them to meet. So they come back, they file an application in the court saying that we want to meet our client. He has a right, we have a right to meet our client, and he has a fundamental right to be defended by a lawyer who he has access to. I think it's Article 20. 22, correct. 22(2). Every person who is arrested and detained in custody. No. Nor shall he be denied the right to consult and to be defended by a lawyer of his choice. So he doesn't have a lawyer of his choice. The court appoints him a lawyer, and these lawyers want to meet him. He's deemed to be a lawyer of the prisoner's choice once he's appointed by the court. The jail authorities do not allow the meeting to take place, and the application is made in court. The application comes before a bench of Justice Ranjana Desai, who eventually decided the confirmation, and Justice Mohd, who was also, this is the same division bench which decided the death sentence appeal. Justice Ranjana Desai, of course, as you know, went on to the Supreme Court. By a speaking order, the application made by the amicus curiae to be able to meet their client and take instructions is rejected in the name of national security. And of course, in the name of the security of the lawyers themselves. The public prosecutor informs the court that Kasab is a trained killer. He can strike swiftly and lethally, and that they cannot guarantee the safety of these lawyers if they were to come within striking distance of Kasab. And that application to be able to meet their client is rejected. Now, fast forward a few years and come to an event that one of your students, Gaurav, was present at. The trial of Headley, also under part of the 2611. Same 2611 trial. Kasab's is over, now Headley's begins. Headley is and somebody who has confessed not in India but around the world, especially in America, to not only being one of the prime conspirators of 2611, but having said repeatedly on oath before judicial authorities, he's very proud of what he has done, and if he could do it, he would like to do it again and again and again. Headley is given an unconditional pardon by the government. All right, if you had something major to gain from Headley, you could give him a pardon. There's nothing wrong in that. If you had more to gain than you had to lose. The man on trial is somebody they call Abu Jundal, Zaki, Zabiuddin Ansari. They call him Abu Jundal, single accused on trial. And in order to get his confession, in order to get his conviction, they give, and to get evidence against Zaki, they give an unconditional pardon to Headley. At the end of his evidence, both chief and cross, Headley hasn't said a word against Abu Jundal. And this is confirmed by the fact that an application was made by the defense, and in reply to that application, the PP said in a signed reply, why is the defense making such a noise? The prover has not said anything against their client. So now you have it on record that for no gain at all, an unconditional pardon is given to this man. So you ask yourself, why? Why was a pardon given to such a dreaded, self-confirmed terrorist conspirator of 2611? And then you start, obviously to get the answer, you will have to read his evidence. And there's nothing in his evidence except that Ishrat Jahan was a terrorist. Which is, of course, why the government gave him the pardon. In order to be able to exonerate the president of the BJP. So this is how easily national security is traded. How easily the phrase is bandied about. But how little conviction underlies it. An event as serious and significant as the 2611 trial is compromised at its very heart in order to give a clean chit to a politician. So be a little skeptical when you hear this phrase, national security, being bandied about next time. Thank you.
Thank you, Yug. I would like to now open the floor to questions. We are running short of time, so we can probably not take all questions that we have. But if some of you would like to ask any one of our panelists anything, please go ahead now.
I just want to ask Mr. Aamir Khan. Actually, Aamir Khan expressed and Mr. Abdul Wahid expressed how the police or investigation agencies have treated them while they were being detained or kidnapped. But I just wanted to ask Mr. Yug Mohit Chaudhary, Dr. Yug Mohit Chaudhary, why they indulge in that kind of acts.
Why the police indulge in these kind of acts?
Yes, because they know very well that these fellows are not the culprits.
Because
still they indulge in harassment and third degree treatment, though they are also human beings, and these fellows are also human beings, which is well known to them.
When an offense occurs of the magnitude of the type that these people have been charged with, and if the police cannot find anybody, they are under a lot of pressure. In order to save their own skin, show a success rate which is not there, and be able to close the file, they falsely implicate people. It's quite common. And they do it skeptically. If you ask Wahid, he will tell you how many times the police who was torturing him told him, yes, we know you have not done it. But क्या करें, superior से order आया है, हमको करना पड़ेगा.
The third year student here. So I wanted to ask Dr. Yug Mohit Chaudhary this question. So do you think there's any inherent value in having a higher rate of conviction? Do you think it's an ideal we should strive for? Because say for example the Justice Malimat committee report, it advocates for lowering the standard of proof because they want a higher rate of conviction, saying that we need to instill society's people's belief in the criminal justice system. Basically, do you think it's an ideal we should strive for?
So, well, according to me and what I understand of the criminal justice system, a conviction rate, any conviction rate, whether it's high or low, does not in itself speak about anything of the standard or the quality of that criminal justice system. A very low conviction rate, on the other hand, could mean that the value of because the question is, how do you measure what is the quality of a criminal justice system? Well, a country like China would probably have a very high conviction rate where an accusation automatically almost leads to a conviction. but we would not, by the standards that we use, generally speaking, consider that criminal justice system to be fair, or for any on any standard to be a reasonable criminal justice system. A conviction rate, and especially if you ask this question in a society such as India, where a criminal conviction is the product of an investigation which is done in manners that you have heard about this entire afternoon, where it is done through trials, and where most often the accused do not have the competence or the resources to hire good counsel. A conviction doesn't mean anything. You have seen how convictions of so many people have nothing to do, far away from the truth itself. So I don't think that a conviction rate has anything to do with the quality of a criminal justice system. But
There are two things over here. One is the aspirations of a government. The government is the prosecuting authority. Surely you would like to win all your cases as a lawyer. That's one thing. Fair enough, one understands that. The government launches a prosecution, would like to win every prosecution it launches. That is a very personal kind of thing. We don't have to go along with that. It's just as at the level of a lawyer wanting to win all his cases. Look at it from the judicial point of view. Does it really matter to the judicial system, and should it, that the conviction rate for murder is 35%? Should it matter? A judge is purely concerned with the quality of evidence brought before him. He has to acquit or convict on the basis of the evidence before him, not on the basis of the statistics as to what is the conviction rate and whether it should be increased or lowered. This is an irrelevant consideration as far as the judiciary is concerned.
So as a defense lawyer, probably in one of these terror offenses cases, and you're faced with a confession of sorts, and the prosecution produces this evidence, and I haven't read the TADA act itself, so I'm just depending on what I've heard of the given sections. So the conviction is the valid evidence. So what can a defense lawyer do in a situation? Can he question the validity of this confession? Like, can he analyze the confession and see this isn't wrong or anything of that sort?
Yes, of course. That's all he has to do. That's all he can do. He has to question the confession. He has to challenge the method in which it was recorded. He has to question whether the safeguards were followed. And that will happen by cross-examining not only the investigating officer, but also the officer who recorded the confession.
Then in this case, if the defending lawyer has been given this right to question it, then how come there's like there are these many convictions in this case? I mean, if every defense lawyer were able to actually put a magnifying glass to that confession, I'm pretty sure this shouldn't be happening, right?
I gave you the example of Balwant Singh from the Indira Gandhi assassination case, whom the prosecution said was found with the full confession in his pocket. It was accepted by the trial court, it was accepted by the High Court. This is what happens. This is a numbing of the judicial sense in high-profile terrorist cases.
So throughout the discussion, you've highlighted how there's a structural problem in almost all forms of the state, whether it be the police or the judiciary. So my question is, how do you move forward from this? What changes or what policy initiatives can be taken by the government to, or from outside?
Do you think the government wants to change it?
No, so my question is, how are we supposed to change this? How are you supposed to change such structural problems?
डॉक्टर साहब ने एक टिप्पणी की कि गवर्नमेंट से उम्मीद क्या रखी जा सकती है। हमको तो मैं समझता हूँ कि जो तब्दीली है, परिवर्तन होता है, वो पहले हमको स्वयं से शुरू करना चाहिए। सिविल सोसाइटी में हम कुछ ऐसे प्रोग्राम करें जो कि पब्लिक अवेयरनेस फैलाएं, हमारे राइट्स क्या हैं उसके बारे में जागरूक करें, और मीडिया की भी बड़ी जिम्मेदारी पड़ती है, क्योंकि जब किसी केस में, ऐसे केसेस में ख़ासकर कोई जाता है तो मीडिया ट्रायल इसमें देखने में आता है और उसका असर कोर्ट में भी पड़ता है। जब कोई अरेस्ट होता है तो 2-3 दिन तक ब्रेकिंग न्यूज़ चलती हैं, लेकिन वही आदमी जब सालों के बाद रिलीज़ होकर आता है तो आप उसके लिए वो ब्रेकिंग न्यूज़ तो छोड़िए, कहीं सेकंड में कोई आ गई न्यूज़ तो बड़ी बात है, या फिर कोने खाँचे में। तो शुरुआत हमको अपनी सिविल सोसाइटी से ही, खासकर आपके ऊपर बहुत बड़ी जिम्मेदारी आने वाली है, तो अपने साथियों में ही आप चर्चा करिए और हम अन्याय के खिलाफ किस तरह कदम उठा सकते हैं, सिविल सोसाइटी के साथ मिलकर ग्रुप बना सकते हैं, अवेयरनेस के प्रोग्राम कर सकते हैं, अधिकार के लिए आगे बढ़ सकते हैं, लड़ सकते हैं। तो शुरुआत तो अपने से होनी चाहिए मेरे ख्याल से।
मैं समझता हूँ एक मूवमेंट हमको चलानी चाहिए सिविल सोसाइटी के अंदर कि ये जो कन्फेशन वाली जो सेक्शन है किसी भी कानून में हो, वो टाडा पोटा मोका गुचको का, वो सब ख़त्म होनी चाहिए। कन्फेशन पुलिस ऑफिसर के सामने होना ही चाहिए, एक चीज़। दूसरी चीज़, किसी भी केस में अगर पुलिस ऑफिसर ने किसी को फंसाया है, ये साबित हो जाता है, वो एक्विट हो जाता है, तो ऐसे सारे पुलिस ऑफिसर पे पूरी जो इन्वेस्टिगेशन टीम है, ऐसा कानून होना चाहिए कि मुझे जाना नहीं पड़े, ये साहब मुझे रिहेबिलिट किया जाए, मुझे कंपनसेट किया जाए, या ये ऑफिसर को वो किया जाए, ऐसा कानून हो, ऑटोमेटिकली वो लोग जो है उनको प्रोसिक्यूट किया जाए, उनको पनिश किया जाए।
I completely agree with what Wahid has just said. The way forward is this. Look, what is happening here is a violation of the rule. And therefore you have to enforce the rule of law. Let me just give you an example of how effectively this can be done, even in just one small step. Bombay is the encounter capital of India. It has the largest number of encounters. The words encounter started from Bombay. And of course we all know these encounters are staged. They're killed in cold blood, and then it's made to appear that they opened fire on the police, and then the police fired in self-defense. And that is the story that is trotted out. All these years, encounters have been continuing rampantly and unchecked. There's been nothing to stop the police from doing it. But encounters have stopped in Bombay. Totally stopped. There hasn't been an encounter in Bombay for four years. How did that happen? Because there was a conviction in one case. Just one case. That's all. That's all it took. In the Lakhan Bhaiya encounter, the officers were convicted, and then nobody dared do it again. If Shingal was convicted or even prosecuted for planting RDX and extorting false confessions and fabricating evidence, other police officers would say, why should I risk my neck? If my seniors want me to implicate somebody, let them do it. Why should I do it? Because ultimately I'll get prosecuted and convicted. If Shingal was prosecuted, it could have started turning the tide. Because this is the only case that I know of where on reinvestigation by another agency, the first investigation was said to be fabricated and false.
मैं चाहता हूँ कि जो चीज़ जैसे कोई किसी को फ्रेम कर दिया जाता है या जो भी है, जैसे किसी को टेररिस्ट मान लिया जाता है, मानने के बाद वहाँ के आसपास का जो माहौल होता है, वहाँ के लोग जो खासकर गांव का, मैं आमिर सर की बात करता हूँ, तो पूरे गांव का, मैं उस समय बहुत छोटा था, तो पूरे गांव का ये माहौल था कि लोग जो है घरों से बाहर, जब पुलिस आता था या पता चलता था तो सब लोग भाग जाते थे, या फिर किसी को लेके जाया जाता था, 2-3 दिन रखा जाता था, पिटाई की जाती थी और लेके आया जाता था, ऐसे छोड़ दिया जाता था और वो उस समय खटिया पे ऐसे पड़ा रहता था। क्या ऐसा कुछ रूल रेगुलेशन है इन लोगों के लिए कि इनको भी कोई भी उठा के लेके जाए और मारे पीटे, ऐसा कुछ है?
बिल्कुल गैर कानूनी है। आम जो आप कह रहे हैं बिल्कुल सही है। आम आदमी से पूछिए, आप नक्सलवाद से ज़्यादा डरते हैं कि अलकायदा टेररिस्ट से ज़्यादा डरते हैं या पुलिस अफसर से ज़्यादा डरते हैं? आपको जवाब पता है क्या मिलने वाला है? ये बिल्कुल गैर कानूनी है। और ये क्यों कर रहे हैं और कैसे कर रहे हैं? क्योंकि अदालत जो है और सरकार जो है उनको करने दे रही है। जिस दिन रोक लगा दी अदालत ने तो रुक जाएगा। एक पुलिस अफसर को सजा लगी, सब रुक जाएंगे।
We will conclude with that. So I would once again thank all of you for taking time out to come. I want to thank my panelists बातचीत हम जारी रख सकते हैं जी. Yes.
I mean, like they give the CD the very same day or the very next day. I mean, like
Keep the CD.
where is the CD? No, I'll tell you one. Like मैं आपसे एक क्वेश्चन है कि जब ये नार्को टेस्ट हुआ था, ठीक है, तो आप सेल में आपने अपने जो साथी जो साथ वाले थे, तो आपने जो है उनको मतलब वो क्या कहते हैं आप अपना जो बटर से आपने उनको बताया, राइट?